Hi, my name is Tom Pryor, and I'm a shareholder with the Stark & Stark Insurance Coverage Practices Group. Today I will be talking with you about the process associated with filing a long-term disability claim. The initial intake of a long-term disability claim begins with an assessment of the claimant's medical condition, which is our discussion with the claimant relating to whether they are, at the time of our discussion, at a point where they are no longer able to continue in their job or occupation. That determination is made by them in consultation with us and is heavily influenced by the discussions that they would have had up to that point with their primary treating physician and any other medical providers with whom they've consulted. We typically review their job duties and occupation in order to form an opinion as to how those responsibilities will match up with the language of the long-term disability insurance policy that will apply to their particular claim. We need to review in detail a full copy of their long-term disability insurance policy, or in some cases, multiple policies that may apply to their individual claim. The types of insurance policies that apply in the context of long-term disability claims are generally categorized in two basic categories. One would be group long-term disability insurance policies, and the other would be individual insurance policies. Most individuals who we see are likely to be covered under a group long-term disability policy, which is typically associated with a type of long-term disability coverage that one would receive in the context of their employment. So if one works for a firm or a corporation or even a small business, it may be common for those individuals to have group long-term disability coverage. Those policies are not as easy to recover under as the other types of policies that we see, which are basically characterized as individual policies. Those are more typical or common in individuals who are engaged in professions such as physicians or attorneys or people in dental practices, for example, who might have purchased those policies as individuals and obtained those policies for themselves alone rather than as a member of a larger group. Those individual policies tend to be more expensive, but they also tend to afford greater levels of coverage, primarily in the sense that those policies are reviewed by the courts if there's a dispute or a denial of coverage under a much more favorable legal standard, which is similar to the standard that would apply in most other types of insurance coverage, which is to say whether the insurance company has reviewed the claim properly, has provided an adequate basis for their determination, and has basically acted in a way that's consistent with the policy language. By contrast, under the group policies, the legal standard is more difficult because those policies tend to be governed by a statute that was enacted several decades ago known as the ERISA statute, which governs group disability policies along with other types of employment benefits. We'll discuss in another segment of this in more detail the nuances of those types of policy comparisons, but for initial intake purposes, it's highly relevant to determine which type of policy or policies we're dealing with. Once we review the policy, it allows us to identify how the policy defines critically the benefits under total disability and in some cases residual disability, which we then incorporate into our identified analysis of the claimant's occupation, duties, and why and how they are disabled. That is a highly relevant exercise because it allows us to understand and convey to the claimant what rights they have under the policy, how readily the insurance company might be accepting of their claim, and what it is that they need to establish in order to perfect a claim. We also engage in the initial intake in a discussion with the claimant of their treating physicians and in the context of their disabling conditions. Some individuals are disabled as a result of some traumatic event, and they may have one treating physician. Other individuals may be disabled as a consequence of a disabling condition that affects them over a gradual period of time, and therefore pinning down a specific date certain as to when they became disabled is not as easy as it is, for example, in the context of a traumatic event where on one day the person is fine and the next day they're completely disabled. And so that analysis must be undertaken. We also look, as we go through the analysis, at the benefit calculation, which is to say the age of the individual, what type of, what amount of income they had been earning and therefore are looking to replace in the context of a disability claim. We may involve their financial professionals if necessary. If it's a physician's claim, it may involve a detailed analysis of CPT codes and other information. But regardless of the circumstances, we need to review with the claimant at the outset what it is that they would be seeking in terms of a benefit, and also assess with them in consultation with their medical professionals the likelihood that they may recover at some point or be disabled over an extended period of time. And so the age of the individual, the likely length of the disability claim matched up with the amount of benefits that may be payable under the individual policy or policies is a highly relevant exercise that we would go through at the outset in order to give the claimant a 360-degree assessment of the relevant considerations that go into whether they are at a point where they are disabled to the point where they need to file a claim, and we would then begin the process of assisting them in putting the claim together, which we will discuss in a separate segment. Thank you for watching. Again, I'm Tom Pryor with Stark & Stark.